NASCAR's legal position is currently in jeopardy as a result of a lawsuit filed by 23XI Racing and Front Row Motorsports. Each of the two teams is disappointed with how NASCAR has handled the situation, particularly the pressure they have placed on teams to sign the new charter agreement for the 2025 season. On the other hand, the more pressing concern at the time is the possibility that some confidential material could be disclosed in the event that this litigation is made public. In the event that this happens, NASCAR, which is privately held, may lose control of a substantial chunk of its business and will be caught up in a public scandal. NASCAR has traditionally maintained a high level of secrecy regarding its finances and corporate activities. They have withheld a large amount of information about their finances, contracts, and even the intricacies of their revenue-sharing model. NASCAR has been able to manage its business with little public supervision due to this secrecy, which has allowed the corporation to keep its decision-making process behind closed doors. On the other hand, now that this complaint has been filed, teams are asking access to NASCAR's internal conversations and files, which could provide insight into how problematic institutions like the charter system operate. NASCAR is most likely attempting to keep this information hidden because they are aware that if it becomes public knowledge, it would be subjected to intense scrutiny by the general public. Because NASCAR is a privately held company, it does not have to publish financial information in the same manner that publicly traded companies do. This allows them to make decisions without being held accountable to shareholders or the wider public. Although this can be advantageous for long-term planning, it also has the potential to cause problems if NASCAR and the teams disagree on issues like this one. If they are forced to submit documents in this lawsuit, it has the potential to open up a whole bag of worms, diminishing the strength of NASCAR's legal defense and revealing activities that may be considered divisive within the sport. One of NASCAR's most pressing challenges right now is the potential for a public relations disaster. If sensitive internal records were made public, not only would NASCAR's image suffer, but competitors would also gain insight into the organization's inner workings. It is possible that they will use that information to their advantage. Maintaining this level of secrecy is critical for NASCAR because it allows them to retain control over the sport in its entirety, from how it is managed to the competitive advantage it enjoys. If the case is successful and previously confidential information about NASCAR's finances, contracts, and operations becomes public, it has the potential to change people's perceptions of the sport. The publication of this type of information has the potential to totally revolutionize NASCAR's operations and regulation, as well as give competing teams or sponsors an advantage when negotiating terms. Competitors may even exploit insider information to construct competing series or events from their own perspectives. This case might have far-reaching consequences for NASCAR and the sport as a whole. NASCAR has a lot at stake, and the implications may be catastrophic. This issue has the potential to be extremely dramatic if any of the NASCAR organization's internal emails or papers are made public. Other teams may begin to question their agreements with NASCAR, advocating for greater transparency and fairness in how the sport administers its financial resources. If any questionable corporate practices, favoritism, or monopolistic activities are discovered, regulatory agencies may suggest enhanced oversight or even launch legal investigations. Because it is a private corporation, NASCAR has had a great lot of independence up to this point. Nevertheless, if these legal concerns grow more significant, that may change quickly. NASCAR may lose its competitive advantage if internal agreements, such as revenue sharing or sponsorship contracts, become public. Other teams or sponsors may use these details to negotiate better conditions, and motorsports competitors may use them to launch their own series. If sponsors perceive that the sport is not being administered in a way that aligns with their views, they may reconsider their support for it. Teams that believe they have been treated unfairly may demand that reforms be implemented. It is probable that NASCAR may lose valuable sponsorship money, which is a crucial part in the sport's financial structure. If the general public realizes that NASCAR is not as open or impartial as they previously believed, it may harm the organization's reputation. It is likely that people will lose trust in NASCAR, and if it is perceived that the organization prioritizes money or select teams over fairness, the number of viewers, ticket sales, and overall fan interest may decline. Finally, this type of exposure may drive NASCAR to change the way it operates, particularly in terms of how teams are treated and money is distributed. This might even threaten NASCAR's long-standing family-controlled model, potentially reshaping the organization's future. At this stage in the ongoing legal dispute, NASCAR and the plaintiffs, 23XI Racing and Front Row Motorsports, have agreed to remove sensitive information from the data being utilized in the lawsuit. Because of this decision, business secrets are safeguarded, and any possible harm to NASCAR's relationships with its sponsors, media partners, and other teams is prevented. By concealing this information, NASCAR avoids disclosing too much information about its business activities, such as the charter system, sponsorship deals, or media rights. This material will be suppressed, so NASCAR will not set a precedent that requires them to divulge all internal facts in future legal processes. As a result of this agreement, the plaintiffs can pursue the action without jeopardizing their standing in the NASCAR world. Because the court and legal teams will continue to have full access to the complete documents, the redacted information will have no bearing on the course of the litigation. The edited versions will only be viewable to the general public, ensuring that the company facts stay discreet while the case is handled impartially. As a result, the fact that certain sections of the legal documents are blacked does not hinder the court from reaching a fair and comprehensive decision based on all relevant evidence. Because of this balance of privacy and transparency, the courts can get a complete picture while keeping sensitive material confidential. When it comes to the legal battle between 23XI Racing, Front Row Motorsports, and NASCAR, it is getting increasingly impossible to predict who will win. Although there are numerous legal concerns at play, it appears that NASCAR may have the upper hand at this time. NASCAR has typically been a privately owned and operated company that is controlled by a family and has much autonomy in how it does business. It has been in place for years, and NASCAR is anticipated to claim that this framework is standard practice to ensure the sport's long-term viability. The charter system, which governs how teams can participate in races, is in effect. When it comes to legal processes, courts often give firms a lot of leeway in deciding how they want to run their enterprises. This is especially true when the judgments under consideration are deemed critical to preserving a healthy and balanced sport. NASCAR is likely to point out that the teams voluntarily signed up for the charter system and profited from it. As a result, this may be construed as a contract disagreement rather than an antitrust violation. It is highly likely that NASCAR's defense will argue that the system is just a component of the game's predetermined regulations, which the teams agreed to when they signed contracts with the corporation. To win, 23XI Racing and Front Row Motorsports must demonstrate that NASCAR is engaging in illegal action by restricting competition or harming the market. This is a challenging argument to present. NASCAR has already said that the case is without substance, citing a contractual dispute rather than an antitrust issue for the corporation to be concerned about. Furthermore, it is expected that they will point out that teams can still compete as open teams even if they do not have charters, undermining the argument that NASCAR is excluding competition. When everything is said and done, the conclusion will be determined by how well the teams present their case and whether the court views the NASCAR charter system as a valid economic decision or one that unfairly restricts competition. It's plausible that NASCAR has the advantage, especially since the system has been in place for years and is used by a significant number of teams. Furthermore, courts prefer to find in favor of private corporations unless there is clear proof that the private company's actions are harming consumers or competitors. Have you got any thoughts? What do you think the outcome of this lawsuit will be? Please leave your ideas in the comments section below. And don't forget to subscribe to receive NASCAR's latest news on the daily.